Okay, Catherine, if we can go on to the next slide, please. That's great. Thank you. Well, we'll make a quick start just with some introductions. There's quite a lot to get through, as you may expect if you've already seen the consultation paper. But again, just thanks and good morning to everyone who's joined for us to discuss the Law Commission and the Contempt of Court consultation paper. For anyone who doesn't know, just a quick introduction for me. My name is Jenna. I am a partner and barrister in the Housing Litigation Department here at Forbes, and I'm delighted to be joined by my wonderful colleague Kirsty Varley, who's also a partner in the Housing Litigation Department. Behind the scenes, we've got our wonderful Catherine, who's manning the slides. So, for the next hour or so, we're going to be highlighting the key issues within the consultation paper. If anybody has seen it already, it's about 500 pages long. So there is quite a bit for us to get through, but we'll do that as quickly and as concisely as possible for you. If there are any questions in terms of housekeeping that you want to ask, we have the chat function at the bottom of the page for you on your screens. If we can't get through to all of those today, obviously we can send up a follow note to answer any of the questions in a little bit more detail. But if there's always appetite, another webinar can be arranged. So just so everybody is aware in terms of what we'll cover today, we'll be concentrating on the proposals that are going to apply to England. Some of those are going to also impact Wales, but we don't have time, unfortunately, this morning to cover all of the differences between England, the English and Welsh regime. But again, if there's appetite, we can arrange another webinar to cover the Welsh side of things. So if we can have a look at the next slide very quickly, this is just our usual disclaimer. It doesn't really necessarily apply today. We're not specifically looking at any legal cases, but it's just to remind everybody that don't take anything we say today's specific legal advice. If you need any assistance, you can obviously contact us directly. Okay, if we look at the next slide, just in terms of the consultation paper itself. So on the 9th of July this year, the Law Commission launched their consultation paper where they're reviewing the law on contempt of court and the consideration of the need for reform in that specific area. So as part of the consultation, what the Law Commission is wanting to hear from is anybody that is involved in the law profession, anybody who sort of is involved with the law of contempt. So it's going to span judges, court users, and obviously yourselves with experience of contempt of court proceedings. Within the consultation paper itself, there are a number of questions that are obviously asked to get feedback that's going to impact the way that it shapes the landscape and the movement forward of the contempt of court regime. There are 137 questions in total. They range from provisional proposals that the Law Commission wants your view on, to more open-ended questions where the Law Commission is really looking for your specific views and input. So it is really important if you are going to be responding and looking at this in more detail that you do look through the consultation paper. There is also a summary document, which is about 30 pages, a little bit easier to digest, but really do have a look through this, and your views are going to be definitely needed in this consultation. So if you look at the next slide, we'll look at the scope of the review. The scope of the review is obviously recommended to review the law on contempt with the aim of clarifying this area of law and improving consistency, coherence and effectiveness. And the scope of the review, as you can imagine, from 500 pages in length, is wide. And the provisional proposals are characterised by four broad lines of reform. They're on the slide there for you. The first of these is move towards clarification and codification. So throughout the consultation paper, the provisional proposals aim to increase effectively certainty in law and procedure around this area. And in some instances, they do involve some substantive changes and reform of the law of contempt. In others, they don't provisionally propose to change the substance of the law necessarily, but just sort of codify the existing common law and measures that will enable judges, legal professions and public as well to understand and have a greater certainty what the law is and what the procedures are when we're looking at contempt. And then we've got second line is transparency and accountability. as it says on the slide as well. The third line is really consistency in ensuring fairness for defendants specifically. And the fourth line of the reform is directed towards enhancing some of the fundamental protections that the rule of law provides, which we'll look at in a bit more detail this morning as well. So if you look at the next slide, please, Catherine, what is contempt of court? So the definition of contempt of court by the Law Commission is set out on the slide, which many of you are going to be familiar with in the sector. But for housing professionals specifically, we've most frequently encounter contempt of court proceedings arising from a breach of an order or an undertaking. Contempt of court is not a criminal offence that we will discuss a lot more this morning, but the sanctions that may follow include imprisonment for up to 2 years, which is called committal, and unlimited fines. So if you look at the next slide, the issue with the current law on contempt. Now, the law of contempt has developed over centuries, but hasn't been, done systematically, and so now comprises of what the Law Commission describes as an unsystematic amalgamation of statute and common law, which has resulted in a somewhat disordered and unclear regime. And some of the problems that have arisen from the confusing distinction between civil and criminal law of contempt, and the multiple ways that contempt can be committed, and the overlap between the law of contempt and criminal offences relating to the administration of justice, such as perverting the course of justice. So the time that we've got today will focus on civil and criminal contempt. So if we look at the next slide, as it says on the heading for this slide, the contempt of court has traditionally been divided into two categories, either criminal contempt or civil contempt. And if you're not aware of the specific distinction there, the Supreme Court in Attorney General and Crossland explained the difference between the two, and this is set out on the slide in those 2 bullet points for you. Now, as I mentioned earlier, neither category of contempt is a criminal offence, though both may result in committal to imprisonment or punishment by way of a fine. While the distinction between criminal and civil contempt is foundational in understanding how the current contempt laws are expressed, what the Law Commission is effectively saying is that the classification of civil and criminal contempt owes more to history than it does to principle and practicality. And as a result of the way the law of contempt has developed, it's become difficult for lay people and legal practitioners alike to identify and understand the relevant law and for the courts to recognise and respond effectively. So the overarching proposal then by the Law Commission is a new framework for liability for contempt. And as a result of some of the issues that I've just mentioned, together with, it's fair to say, many additional considerations within the lengthy consultation paper, the Law Commission considers that the current framework for liability for contempt isn't fit for purpose, and the distinction between your criminal and civil liability is unnecessary and unhelpful. So what the Law Commission is effectively doing is proposing to remove the distinction between criminal and civil contempt. And this is the first question within the consultation paper for you to consider. So what you'll see on the slide there is C consultation question 1. And what we've done throughout these slides for you is just to highlight the consultation questions that are relevant to each particular slide, just to make things a little bit easier for you when you're reviewing the consultation paper yourselves. So what will the proposed framework, look like? If we look at the next slide, thank you. Under the proposed new framework for liability for contempt, instead of there being this distinction, as I've mentioned, between criminal and civil liability, the new framework could comprise, obviously this is just ideas at the moment, could comprise of 3 forms of contempt. And they're on the slide there for you. It's general contempt, contempt by breach of order or undertaking, and contempt by publication where proceedings are active. What we'll do this morning is just focus on the first two as they're more relevant to our sector. What you'll see within the consultation paper is there are chapters and chapters on each of these new proposed forms of contempt, but we've summarised the bare bones for you within the next few slides. So if we look at the next slide of general contempt then. So firstly, the Law Commission proposes a general form of contempt. And under the provisionally proposed framework, liability for this form of contempt would have two strands: general contempt committed by publication and general contempt committed by conduct other than publication. Obviously, the key issue here is whether the conduct was by publication or not. And where the conduct is by publication, contempt would be committed only where a person intends to interfere with the administration of justice. And where the conduct is not by publication, contempt would be committed where a person intends to interfere with the administration of justice. And this form of contempt, the general contempt, would encompass any conduct that interfered with the administration of justice in a non-trivial way, or that created a substantial risk of non-trivial interference. Helpfully, the consultation document itself outlines some of the examples of conduct that the Law Commission would consider would fall within this general contempt. Some of those examples are disrupting court proceedings. This may include, there are some examples on the consultation document, a refusal to sit in the appropriate seat in court against a judge's direction, shouting or singing in court. And for those who deal with ASB, that is an all too frequent feature in my personal experience. Also interesting to note that it doesn't just encompass in-court proceedings. It will also encompass remote proceedings, which is obviously going to be helpful for those hearings that are undertaken remotely. There's also insults, and there's, moving forward, conduct associated with disobeying orders. That's going to perhaps include when somebody encourages another to breach an order, that person's conduct would be recognised as contempt and be captured by general contempt. Providing false statements. Obviously, we're familiar with the statement of truth within our pleadings and our evidence, and then misconduct by legal representatives. And the relevant questions that are going to be applicable here are going to be consultation questions 3 to 17. We obviously don't have time to go through all of those today, but there are some really interesting questions, I thought. There are some very complex ones too within this section. Some of them cover issues such as whether the law of contempt should continue to apply even before proceedings have commenced, and whether these non-exhaustive lists of examples of conduct that would be capable of constituting this general form of contempt should be included. And so it would be worthwhile perhaps reviewing those internally. Okay, if we look at the next one, contempt by breach of order or undertaking. So this is a broader form of contempt than civil contempt, although it is quite similar in its form, in that it would be breaches of any court order within its scope and not just those made for a benefit of a party in litigation. But as with the current civil contempt, it won't simply apply to any order of the court. And so to fall within its scope for this sort of contempt, the order or undertaking would have to clearly state on its face that failure to comply would constitute contempt of court, which is what we would know in the legal profession as a penal notice. So for our purposes today, the main orders that this is going to apply to us in practice is going to be our mandatory or our prohibitory injunctions, which will include your ASB injunctions. So as it says on the slide, this form of contempt would be committed where a person breaches an order or undertaking. The act or omission that constitutes the breach is deliberate. And this does not mean that the person needs to have deliberately breached the order, but the action or perhaps the inaction that did breach the order must have been deliberate in the sense that it isn't an accident. Then C, the person has knowledge that the order existed and that they're bound by it, not necessarily that they knew the terms of it. And as the law stands today, there can't be a finding of contempt against a person who did not know that they were subject to a court order. And they must have therefore had notice of that order if they're going to be expected to comply with it. And that's obviously practical purposes. An order is not enforced until it has been personally served or served in a manner in accordance with a court order. And whilst that is currently the case, the provisional proposal by the Law Commission is that there should be no requirement to show that the defendant knew the precise terms of the order beyond showing that they knew that they were simply bound by an order, and reflects the general doctrine we have at the moment of, ignorance of the law is no excuse. And then finally, the person has knowledge of the facts that makes the conduct unlawful. And then looking at liability for this form of contempt, which is consistent with the existing law for proving civil contempt when an order has been breached, would be established by proving that principally the defendant has failed to comply with the order or undertaking, and that they knew that there was a court order or undertaking, that they were bound. Interestingly, the mention in the consultation document about trivial breaches, and for those who may have experienced breaches perhaps of an exclusion zone, and there's representations made by tenants or defendants solicitors that say it's a trivial breach, that's really not taken into account by the Law Commission. And what they're saying is that there should be no threshold with regards to triviality. And what they're saying is that a breach of a court order or undertaking, particularly one that's been reinforced by a penal notice, constitutes a non-trivial interference with the administration of justice. So triviality, when we're looking at breaches, is not something that the Law Commission believes that the courts should be taking into account. And I think, for a personal perspective, that's the right approach to take. That being said, whilst there's no proposed threshold with regards to trivial breaches, the nature and the consequence of an alleged breach will nevertheless matter, as it obviously does today. Another key feature that we'd look at is interim coercive remedies, which we'll have a little look at more in more detail shortly. And just finally, the burden of proof is going to be the same as it is now, which is the criminal standard, and the relevant consultation questions are set out on the slide there for you. If we look at contempt by publication, this is the third form of specific. If we look at the next slide, please, Catherine, thank you. Contempt by publication when proceedings are active. It isn't necessarily something that's going to affect our sector that much, so we will move on for the time that we have today and look at the next slide, please, Catherine, of interim coercive remedies that I've just mentioned. So contempt applications for breaches of orders are increasingly common, and for your perspective, you may consider, expensive, albeit necessary. And one of the issues that the Law Commission has identified, and we've certainly experienced firsthand, it's not uncommon for those that are bound by an order or undertaking to refuse to comply with it until an application for contempt is made, or in some instances where they're found to be in contempt. So as the law currently stands, the coercion to comply perhaps with orders or undertakings exists only in the threat of sanction once a full contempt proceedings have been commenced, as there's nothing simply at the moment sort of an ongoing coercive remedy for ongoing non-compliance. And in some instances, as you may have experienced, when a sanction is imposed by contempt proceedings, such as a fine or committal to prison, these aren't always going to be effective tools to secure compliance with an order or an undertaking, because they aim to punish the person who's committed the contempt after the fact. And on occasion, punishment in the form of imprisonment perhaps isn't going to resolve the breach. So, for example, in your breach of tenancy injunction cases, simply sending somebody to prison or having a suspended sentence for an untidy garden or property condition simply isn't going to get to the root cause of the issues that you're experiencing internally. And what you may have experienced as well is that the current form of contempt, if a defendant is found liable for contempt, the current process isn't always an effective tool to encourage ongoing compliance, which many of you may have seen in your repeat offenders, perhaps where you're going to court for alleged breaches on a weekly or sometimes daily basis. And so, in response to this, the Law Commission's considered whether the courts perhaps should have the powers to consider and impose certain interim remedies to coerce compliance without having to start a formal contempt application. That being said, whilst there is this opportunity here to consider an interim remedy, you wouldn't lose the opportunity to apply for contempt proceedings later on if you needed to. So if we look at the next slide in interim coercive remedies, then in a little bit more detail. So there's a number of questions on the slide there, looking at the way that the Law Commission has considered the proposals. So when should an interim remedy be available? Well, firstly, the elements of contempt would be made out. So the Law Commission's taken the view that an interim remedy should only be available if the court is satisfied, and that would be on the balance of probabilities, so the civil standard, that the elements of a contempt of a breach of order or undertaking have been made out, albeit there would not then be a finding of contempt. There's a breach capable of remedy. So if an interim remedy is more of a coercive rather than punitive in nature, it would only be available where the continuing effect of non-compliance can be remedied by subsequent compliance. And what the Law Commission said here is that if the balloon is popped, so to speak, there's no point in trying to reinflate it. And then standard of proof, as I've just mentioned, is the civil standard balance of probabilities. And then what remedies should be available? And I think this is something really in our sector that we should be considering. The Law Commission accepts that interim remedies won't be an assistance in all cases. But in circumstances where a party is determined to disobey an order or put themselves beyond the reach of the court, an interim remedy may be of little help. But perhaps if we're looking at first breaches or looking at the specific facts of a particular case, there's a number of remedies that have been suggested. Firstly, that the defendant pay a fixed, perhaps periodic deposit of money into courts that could be returned upon compliance, sequestration of assets, or an order that surrenders, the defendant requires the defendant to surrender their passport or another way of prohibiting them from leaving the jurisdiction. And one of the things that I was thinking of when looking at this section is whether this really goes far enough or whether it's going to be applicable in our sector and whether we really need to consider this and respond to the Law Commission on these points. When we're looking at deposits of money, for example, do you consider that would work? Is that enough of an incentive? A lot of the time we identify that some defendants would prefer not to, for example, to pay costs and accept an injunction or an undertaking instead. And so perhaps financial punishment may be enough, but whether a tenant or a defendant would have enough funds to be able to surrender, how that may impact perhaps any benefits, and whether it's going to give enough of a prohibitory or a deterrent, so to speak, for them if they realise they may have to pay some money into court if they breach this. Some defendants may work with that. But there is a consultation question, number 28, which asks those considering this consultation whether any other interim remedies may be appropriate. And I think sometimes as a sector, this is something that we should really be, considering in a lot of detail. And then there's just some additional information here about fixed terms. And the Law Commission simply of the view that in order to avoid interim remedies being innately punitive, they should be enforced for a fixed period of time. And then subsequent contempt proceedings and double counting, the effect of the interim remedy isn't going to serve to debar contempt proceedings effectively, but any subsequent sanction for contempt in applications that you make subsequently would have to take into account the fact that an interim remedy has been imposed. Okay, if we look at the next slide then, contempt, protection and powers. Having looked at, provisional form of the way that the new framework for contempt liability may stand, what the Law Commission then does is goes on to address a number of discrete issues in the remaining chapters of the consultation documents. And within this section, specifically of the consultation, the Law Commission uses phrases such as protection and powers and for the framework of analysis of how the law of contempt applies to courts effectively. And the meaning of that is on the slide for you there. And what the Law Commission is doing is suggesting that the protection and powers are inconsistent and unclear and often vary depending on the nature and the conduct and the specific court in which the issues are taking place. So if we have a look now at contempt and protection on the next slide, I'm just going to move this down because I can see my face is half in sunlight and half it. There we go. So contempt and protection. So the proposals by the Law Commission seek to achieve clarity, consistency and coherence across protected courts, tribunals and other bodies, meaning that all such bodies will have the same powers to deal with contempt effectively. And the reason for this is that currently we have a hierarchy system in the courts, which have two broad categories of superior and inferior courts. And so superior courts, for example, we're looking at the High Court and Court of Appeal Upper Tribunal, and inferior courts, County Court, Family Court and Magistrates. And what the Law Commission then goes on to do is have a look at how some bodies are identified as being a court and whether they are, for example, exercising the judicial power of the state and whether, to identify a court is whether it was established by Parliament, sits in public and can award costs. It shouldn't really impact the county court necessarily or the first tier tribunal property chamber, as they have provisionally both been identified as courts for the purpose of contempt. So they may be protected, but what the consultation is looking to do is ensure that, for example, the county court is listed in a non-exhaustive list of inferior courts with contempt protection. There is some grey area in terms of other chambers of the first tier tribunal, but I think that really forms outside the scope of today's webinar. So the relevant questions to consider here is consultation questions 41 to 43 and the proposal to retain the current test for determining whether a body is a court, as I've just mentioned, and whether to have a non-exhaustive list of superior and inferior courts. Okay, if we look at the next slide in terms of powers. So once we've looked at the sort of courts that could be protected by the law of contempt, the Law Commission turns its attention to the powers that these courts should have to address apparently, behaviour that constitutes contempt. And the existing powers to deal with that sort of conduct are set out on the slide. And what the Law Commission is doing again is highlighting that they think two significant problems arise within the existing contempt powers and protection of inferior courts. And firstly, that is going to be there's often difficulty to identify what powers a body has to address apparently contemptuous conduct. And then secondly, the powers of inferior courts don't apparently at the moment allow contemptuous conduct to be addressed effectively. So whilst the superior courts are going to have retained their powers to deal with any contempt affecting their proceedings, to address the lack of clarity within the powers of protected bodies and concerns that some bodies are ill-equipped to deal with the administration of justice, the Law Commission is saying that a simpler and more uniform framework of powers for all protected inferior courts should be applied. Okay. If we look at the next slide, then procedure in contempt proceedings. So what the Law Commission is describing here is as I say, a clear, comprehensive, and where possible, uniform procedure that enables courts, tribunals, and other bodies to deal fairly, efficiently, effectively, and consistently with conduct that may constitute contempt of court. And the relevant chapter here in the consultation document spans about 7 different parts. So we'll just really try and narrow this down for the purposes of this morning. So the main issues that we'll look at today that are relevant to our sector is harmonisation and clarification first. And some of the issues that the Law Commission have identified here is that there's different regimes, processes and procedures for dealing with contempt across the different courts. So whilst the criminal courts may have different processes and procedures to deal with different types of contempt, in the civil courts and the family courts, there's only one. Secondly, there's inconsistency in language that's used. So we now describe contempt proceedings as, claimant and defendant, whereas in the magistrates' court, they still, applicant and respondent. So there is a difference in the language there. And then there's a lack of detail and completeness in the procedure and guidance. And this has come from, not solely necessarily, but there's a member of the senior judiciary that told the Law Commission that they were looking at trying to draft guidance for Court of Appeal judges to deal with contempt in the face of the court. And they were really struggling to do that with the way that the rules currently stand. And then imprecision of a concept of summary procedure. And then to overcome these sorts of issues, the Law Commission considers that harmonisation and clarification procedures to be followed in contempt are going to be necessary. And like I've said, they're looking at this uniform general procedure, which the relevant question there is going to be number 65. The Law Commission does, though, accept there's going to be some variation here, and so it's not going to be as uniform, perhaps, as it appears on first blush. Then looking at fair trial procedure, what the Law Commission is saying is that, contempt is considered a criminal offence for the purpose only of Article 6. And so all contempt proceedings require compliance with the requirements to a right of fair trial. Instituting then proceedings on application. This, I think, section is particularly interesting for our sector as it deals with applications for contempt that we regularly deal with. And what the Law Commission has identified is that when making an application for contempt, there's a difference between the information given in civil proceedings and criminal proceedings. And what the areas of reform in terms of the Law Commission here are looking at the information, firstly, that's provided to the defendant. And as it currently stands, in criminal contempt, there is far less information required than there is in civil contempt applications. And so the Law Commission is suggesting a move towards clear and detailed information to be provided to the defendant, which really is moving towards what we consider, the civil contempt side of things. And then types of evidence that may be used. And this is particularly interesting for those who do deal with contempt applications. First, there was two concerns raised. Firstly, the type of evidence that's required. And this is because at the moment, within the civil regime, unless the court dispenses with it, the civil procedure rules require evidence in support of a contempt application to be by way of affidavit. In contrast, the criminal courts allow witness evidence. And what the Law Commission has found during their pre-consultation engagements is that there's no real explanation as to why those two procedures sit, or why affidavits are still required in the CPR. And unless there's sound reasons for different approaches, it seems like consistency, again, is going to be preferable. And the question arises, is it appropriate for witness statements to be used rather than affidavits? And from a practical perspective, getting a witness statement signed is much easier in our experience than getting an affidavit sworn. And perhaps that's something that you will be considering when responding to this. And then second concern is regards to hearsay and the admissibility of hearsay within contempt applications themselves. Okay, if we look at the next slide then, in terms of procedure in contempt proceedings, interestingly, the procedure for hearing a contempt allegation was a subject of significant stakeholder concern, apparently, within the Law Commission's pre-consultation meetings. And the concerns related primarily to the procedure set out in CPR 81, which we deal with when we're looking at contempt applications. And what they were told, the Law Commission were told, was that the CPR lacked specificity. For example, it doesn't provide explicitly for an opportunity for the defendants to admit conduct, introduce evidence, or make representations. So what we see is the procedure on the left-hand side and the right-hand side of the page with regards to current civil procedure rules and criminal procedure rules. And what you can see from that is that the criminal procedure rules are significantly more prescriptive than CPR is. And if we look at the next slide, very quickly, what judge should conduct the hearing, and what really is dealt with here is the fact that in some criminal cases, some judges who hear or experience contempt in the face of the court can then go on to deal with that application for contempt. It doesn't really happen in our applications, because if there's an allegation of contempt, it's not necessarily the same judge that's going to be hearing it, unless, of course, they're reserved to themselves. But the relevant question is within 86. And then publication of contempt proceedings. Again, it's something that may affect the criminal courts more than the civil courts, because CPR, as it currently stands, when a sentence of imprisonment, either immediate or suspended, is passed in contempt proceedings, the judgment must be passed and processed and published on the website of the judiciary in England and Wales. This isn't, there's no corresponding provision in the criminal procedure rules. And so in the absence of a published contempt judgment for criminal courts, it means that there's a lack of transparency that we currently have in the civil side of things. And what the Law Commission is proposing is that where there is a committal, there's a strong case of publication. I think that in the interest of justice and fairness, that is appropriate, even if a judgment is short. But what I'll do now is pass over to Kirsty to have a little look at the representation in contempt proceedings and everybody's favourite topic, sanctions. Thanks, Kirsty.
Thank you, Jenna. So moving on to representation in contempt proceedings, and we've really picked out here what we think is most useful. So legal aid in contempt proceedings and means testing. When a defendant receives legal aid in contempt proceedings, they get criminal legal aid as opposed to civil legal aid. This is regardless of the court in which the proceedings occur, and regardless of whether the proceedings are for civil contempt or criminal contempt. However, criminal legal aid is means tested if proceedings are in the criminal court, but not if the proceedings are in the civil court. So while this can impact the criminal courts more than the civil courts, what it means for those finding themselves in the criminal court is that they'll only receive legal aid if they qualify in terms of the finances, where in the civil court, the defendant will get legal aid regardless of the financial resources. So the example that the Law Commission uses is that a potentially vulnerable defendant on low income who's breached an antisocial behaviour injunction and faces a committal order in the county court gets legal aid, and a wealthy person who lied on a witness statement as part of an insurance claim, with the insurer starting a contempt application in the High Court, legal costs then running into tens of thousands, will also get legal aid. And while the Law Commission accepts that there are arguments for and against having means testing in all contempt proceedings, the provisional view is that means testing for legal aid should apply in all contempt proceedings. And so the Law Commission is seeking views as to whether there are any categories of cases that should really be carved out as exceptions where means testing shouldn't apply. And this is Consultation question 95. So is this likely to impact on our contempt cases? Perhaps you want to have a think about that. And in terms of costs, the relevance of the defendant's means, the courts have made clear that costs in contempt proceedings are not in some special category and the general principles apply. So this means that costs against defendants in the criminal courts are limited to the amount that the defendant has the means and ability to pay, but there's no requirement that the civil court takes into account the defendant's means when making cost orders. This isn't particularly desirable, this inconsistency, especially where the orders for costs in civil court can be made against the defendant for breaching an injunction where the individual's got little or no means or ability to pay the costs. So the Law Commission is asking you whether in a civil court, contempt proceedings should be required to consider the defendant's financial resources when making decisions about cost orders. And that's Consultation question 98. Now, I'm not sure whether this is particularly attractive for our clients, for housing associations, for local authorities. Does this mean you're unlikely to ever get a cost order? I mean, in practice, judges do consider this sometimes in any event. But then again, is it fair when you legitimately bring contempt proceedings that you might have no prospect in the future of getting your costs back simply because the defendant doesn't have any income? So maybe you want to think about this when you're bringing proceedings in terms of how judges view cost orders. So can I have the next slide, please? And we're looking at the sanctions regime for contempt of court. And after a court makes a finding of contempt, it can impose a sanction. Currently, the main sanctions really are imprisonment, which are immediate or suspended, and or a fine. For breaches of injunctions and undertakings, the only penalties that I really come across are immediate or suspended terms of imprisonment. And the ultimate aims of the sanctions are currently twofold. Firstly, to punish the individual who's committed the contempt, and then secondly, to secure the defendant's compliance with the court order in the future. Now, looking at powers to impose sanctions for contempt. In the consultation, the Law Commission considers the sanctions that may be imposed by both superior and inferior courts, tribunals and bodies, which we're going to summarise. And under the current law, the powers of the courts to impose a sanction for contempt vary. Section 14 of the Contempt of Court Act 1981 provides for these maximum sanctions which are set out on the slide. And we mentioned earlier that a county court would likely be classed as an inferior court generally. However, for the purposes of imposing sanctions, a county court is classed as a superior court, and so it can impose a maximum prison sentence of 2 years and an unlimited fine. And the Law Commission has provisionally proposed that this should remain the same, and that if there are wider ranges of sanctions allowed for superior courts, that these should apply to the county court too. And this is Consultation Question 117. The maximum sanctions for the superior courts are likely to remain the same, and this is Consultation Questions 100 and 111. And in respect of inferior courts, tribunals and other bodies, the Law Commission has a provisional view that there should be consistency in the sanctions regime, and that the courts and tribunals should all have the same sanctions and powers as each other. And the proposal is set out on the slide. So firstly, the power to order committal for up to a month, either immediate or suspended, and the power to impose a fine of up to £2,500. If I can have the next slide, please. And so looking at suspended sentences, as we've mentioned, immediate committal isn't the only option. Sentences can also be suspended. And a suspended custodial sentence can only be imposed when the custody threshold has been passed. So this means that the court first has to determine whether the conduct warrants a custodial sanction, and then it can go on to consider whether it should be suspended or not. And in the context of contempt, where the custody threshold's met, superior courts have a power to suspend an order of committal for such period or on such terms or conditions as the court may specify. So the sorts of conditions that we typically see in injunction cases, for example, prohibit the defendant from committing further contempt while the injunction is in force, compliance with the injunction order. In practical terms, the power to suspend is an important sentencing tool. It can secure compliance with orders and injunctions. It allows the court to take account of individual circumstances, and it really gives some flexibility in the way that the court can sanction breaches. And in relation to suspended sentences, the Law Commission considered whether there may be a case for greater clarity about the options for suspending sentences for defendants, and that this should be set out in statute. So the Law Commission is seeking your views on this. This is Consultation Question 103. And the next slide, please. And here we're looking at sanctions options. So as you'll know, sanctions for contempt of court can be severe, so it's important that the law is clear and consistent. And in the consultation paper, the Law Commission considers various aspects of the existing sanctions options, for example, suspension of sentences, as we've discussed, early release and discharge. In essence, the Law Commission is proposing that defendants who've been committed to prison for 12 weeks or more should be eligible for early release on tag or home detention curfew up to 180 days before their automatic early release date, and that's Consultation Question 108. Sanctions for contempt by publication and sanctions for contempt by breach of antisocial behaviour injunction. The Law Commission is specifically asking you how the law should be clarified, so maybe have to think about that. The Commission's also asking whether the sanctions options are fair and proportionate, and whether the courts have sufficient powers to ensure the appropriateness of any sanctions for vulnerable individuals, so for example those with mental health conditions, and children and young people. The main concern raised, which has been raised in many contempt hearings that we deal with at Forbes, is that the range of sanctions in the civil courts are extremely limited when we compare them to, for example, the criminal courts who've got the availability of community sentences. And in response to this, the Law Commission suggests 4 core provisional proposals to reform the sanctions regime, some of which we're going to look at over the next few slides. So we can have the next slide, please. And here we're looking at pre-sentence reports. Civil courts don't currently have the power to order a pre-sentence report or a PSR when sentencing for contempt, but they are available in criminal courts. And the purpose of a PSR is to facilitate the administration of justice and to reduce offenders' likelihood of reoffending. And what the report does is to assist the court in determining the most suitable sentence, including whether to order a custodial or community sentence, and then to tailor any community sentence so that it's suitable for the individual offender. The Law Commission thinks that the absence of reports from contempt proceedings is a shortcoming. I have to say I agree. And it means that vulnerable individuals who are sometimes unrepresented appear before the court for sentencing without the vulnerabilities being sufficiently taken into account. So if a pre-sentence report was required, any vulnerabilities of the individual and their personal circumstances would become evident, and that would enable the court to determine the most appropriate sanction. And although preparing a pre-sentence report requires resources, the prepare a pre-sentence report when sentencing for contempt, as the benefit outweighs the burden. And this is consultation questions 104 and 105. And in relation to pre-sentence reports for breaches of injunction, the Law Commission has been told by stakeholders that a pre-sentence report would be especially valuable where contempt proceedings are for a breach of an ASBE, as many injunctions are sought against vulnerable people, many of whom have mental health issues, and the incidence of mental health vulnerabilities is higher amongst those who breach ASBEs than those who commit other forms of contempt. And the provisional view of the Law Commission here is that a pre-sentence report would be valuable where an ASBE has been breached, but that's not the only scenario where it would be valuable. So in fact, they go further and suggest that the better position would be for a pre-sentence report to be required in every contempt case unless the court decides it's not necessary in the circumstances. Now, this obviously raises questions of funding. Who's paying for this if the defendant's unrepresented? Will it be you? Also, we can't force a defendant to undertake a mental health assessment, and in our experience, a defendant is much less likely to comply if the report is sought by their landlord, for example. And also the role of the probation service here. Are they going to be involved? And if they're not going to be present and or have the powers, then how will the reports be prepared and who's going to prepare them? And then looking at remands in custody prior to sentence. The courts don't currently have any general powers to remand a person in custody after the finding of contempt but before sentencing. But if courts have the power to obtain pre-sentence reports, they may also need a power to remand the person in custody while the report's being prepared. And in most instances, when a report's being prepared to inform the sentencing, the person should be entitled to bail, as in the ordinary criminal context. So we're thinking here of the presumption of bail. However, where a custodial sentence is likely, the court may need to remand the defendant in custody, and we don't currently have that power. And in the context of contempt, the provisional view of the Commission is that it would be appropriate to provide courts with the power to remand the defendant in custody prior to sentence, so there is time for the pre-sentence report to be obtained, but only where an order of immediate committal is highly likely, and this is consultation question 106. And where this happens, the Commission suggests that not only should any time spent on remand be taken into account when imposing a sanction, that this should happen automatically, as it does in the criminal context. And this is consultation question 107. So what do you think about this? Do you think that spending time on remand before a pre-sentence report is prepared would act as a greater deterrent? And also in reality, how often a defendant sentenced to an immediate term of imprisonment? So perhaps things to think about. If we can go to the next slide, please. So here, where a community sentence is an order that a convicted person does or refrains from doing certain things. So, for example, there may be a requirement to do unpaid work in the community, a requirement to adhere to a curfew, or a residence requirement, undergo mental health or drug and alcohol treatment, or restrictions and monitoring of the whereabouts. And currently, community sentences, which are alternatives to custodial sentences, aren't available as a sanction for contempt of court. And by contrast, when sentencing a criminal offender, Courts may order a community sentence, and they've long been used and to good effect in the criminal context as an alternative to imprisonment. So in pre-consultation engagement, the Commission was told by judges and the legal profession that the inability to impose community sentences for contempt is a significant gap in the options available to the court. We've heard similar comments made by judges in contempt applications that we've made, and I have to say I do share that view. And I would say that the introduction of the community sentences would give the courts powers to deal with specific issues that are causing the breaches to occur in the first place. So, for example, getting to the root cause, such as drug or substance abuse issues. And a community sentence in this context could provide a more rehabilitative, focused sentencing approach rather than simply sending someone to prison, which doesn't assist with the root causes or the issues, or granting suspended after suspended sentence, which allows the defendant to return to the community with no support, they're then bound to reoffend. And as we often see, a stern word from a judge really doesn't hold a lot of weight if somebody's got addiction issues, for example. So the Law Commission suggests that community sentences should be available as a sanction for contempt of court. This is consultation question 114, and we'd be really interested in hearing your views on this. So if we can have the next slide, please. So when defendants are sentenced in criminal cases, the courts refer to sentencing guidelines produced by the Sentencing Council for England and Wales. And the sentencing guidelines ensure consistency and transparency in the sentencing of offenders. There are no guidelines for sentencing for contempt because contempt is not a criminal offence. Over time, the courts have developed general principles to apply when sentencing for different types of breaches. However, the lack of specific guidelines means that in contempt cases, there are inconsistencies in sentencing and there is a lack of transparency overall. So if we look at the guidance from the courts for contempt cases in civil context, this is most appropriate for what we deal with from breach of an order or an undertaking. The Court of Appeal provided guidance in 2022 in the case of Lovat and Wigan Borough Council. And in this case, the court emphasised that securing future compliance is the principal objective for sentencing before punishment and then rehabilitation. And secondly, the court adopted the 10 principles set out by Lady Justice Hale in Hale and Tanner, all of which remain applicable to civil cases with suitable modifications of examples given in a family context. This is a family case. Thirdly, the court made an observation that sentencing may be adjourned to give the defendant an opportunity to comply. We do see that sometimes. And fourthly, the court considered the harm and culpability, which each have 3 different levels and categories, as it shows on the slide, which I'm sure many of you will be familiar with. The provisional view of the Commission is that there's a strong case for development of guidelines for sentencing for contempt. It's unsatisfactory that courts will have to apply guidance which has been set out in case law. Sometimes they'll legitimately draw on criminal sentencing guidelines as points of reference, but there's no really precise or predictable approach as to how that should be done. So they're proposing provisionally that sentencing guidelines should be developed by a judicial working group. And this will draw together a range of expertise on sentencing contempt in different cases. And this is consultation question 121. This obviously won't happen overnight. It'll involve establishing a working group to prepare any such guidelines, but it would be interesting to hear your thoughts on this. If I were pushed, I would say I think it's a good idea. Clients will often ask me when we're looking at contempt proceedings, that a breach has been proven. I'm then often asked, what do you think the likely sentence is? And sometimes it can be how long is a piece of string, or depend on the different judge that you get. So some clarity and certainty would be good. If we can move to the next slide, please. So here, the Law Commission is asking a very straightforward question. Should a finding of contempt appear on someone's criminal record? This is because there's some confusion as to when contempt is entered into the Central Criminal Records Database, or PNC, and it appears on a criminal record certificate. So as we've already mentioned today, finding of contempt isn't a criminal offence, and as such, there's no conviction. So what the Law Commission is saying is that contempt should not be entered onto PNC, and it shouldn't appear on a criminal record. This seems pretty sensible, really, as criminal records have very serious impacts on people's lives, and the Law Commission provisionally concluded it should be made clear that contempt should never be entered into the PNC and should never appear on a criminal record certificate. And this is consultation questions 122 and 123. So if we can have the next slide, please. So the rest of the consultation deals with 3 issues that are on the slide. We don't have time to go into these in any great detail, but in summary, firstly, the recording and publishing of sanctions data. So the Commission's identified that criminal findings and sanctions aren't recorded systematically in the justice system, so it's not possible to obtain figures or understand what sanctions have been imposed. So because of this data gap, the Commission's provisionally proposing the publication of annual data in relation to committals for contempt, and the consultation questions here for you to look at are 124 and 125. Secondly, appeals. So the framework for appeals from an order or decision made in contempt proceedings is quite complex, and the Commission in its consultation is considering two alternative options for reform of the routes of appeal in contempt cases with a view to making the structure clearer and more coherent. And the consultation question there is question 129. And finally, thirdly, the impact. So the Commission acknowledges that recommendations for law reform must be informed by economic and equality impacts that the changes would have. So throughout the paper, and in particular in Chapter 12, the Law Commission considers the economic and equality impact of our provisional proposals. And in addition to providing questions relating to specific issues, such as the impact of sanctions on those who lack capacity, or children and young people, this is consultation questions 105, 110 and 115. We're asking for evidence on the impacts in relation to any combination of the proposals or the overall effect of them. And that's consultation questions 136 and 137. And go to the next slide, please. And before we bring this webinar to an end, we've summarised the key dates and information to respond to the consultation on this slide for you. And I think that just about covers everything, Jen, unless you wanted to add anything.
No, nothing from me. You know, with 2 minutes to go, with the amount of information we had, I think we've done well.
A whistle-stop tour, I think, is the phrase.
It certainly is, and there's so much to go through with this. So I appreciate that we've just been able to sort of scratch the surface. But for anyone who's sort of really looking at sort of the consultation and how it's going to sort of change the landscape, then, you know, I think it really is important to have these conversations. And if there's sort of working groups perhaps that are set up, then obviously we'd be more than happy to get involved with that, to sort of look at it from, you know, the legal perspective and how it's going to impact, you know, your organisations moving forward. But I certainly think that the scope for these questions that are being asked, I know there's so many of them, and some of them aren't really aren't applicable to our sector. But for those that are, I think getting in touch and sort of, you know, responding to this consultation is really important, because I think it really is going to perhaps change the way the courts are able to deal with contempt, and the interim remedies and things may be invaluable to us if we can get ones that really are going to apply. Yeah, and so rather than sort of sitting back going, oh, I don't really like what the Law Commission's done, it's giving us the opportunity now to really engage and get you know, involved with this and change hopefully the landscape for the better. If anyone has any questions, I appreciate we were a minute out, and we've probably bombarded you with a load of information. I'm all contempt consultation out now. But if there is any questions, obviously you can feel free to ask. But we've got in the next, I don't know whether it's the next slide, Catherine, we can put in on the final slides with our, you know, you'll get these slides and we'll get the recording as well, I'm sure. But if anybody has any questions, you can email us directly as well, and we'll obviously have that opportunity to continue the conversation there. Okay, I don't think we've. I mean, it's a lot of information.
Yeah, I don't think there's anything. Is that I was just going to say as well. I think it's really important that you have your say, rather than have changes imposed on you and then decide you don't like them afterwards. Really sit down and have a think about, you know, if there's anything that you would like to see, put it in there, because you never know, they might decide it's a good idea. Oh, I think we've got a question here, Jen.
Will judges have the opportunity? Yes, yeah, it's for everyone in the sector. So there's going to be judges, lawyers, housing associations, literally anybody that can be affected by the contempt regime have the opportunity to respond. And I know that a lot of judges were involved in the pre-consultation engagements. So yeah, judges will have the opportunity to feed back on this. And I think certainly if judges are doing it, we should be as well. And we can get these slides over to you, hopefully, Catherine, this afternoon, maybe, if you need them, you know, as soon as possible. But like I said, the document itself is 500 pages long. It's quite imposing, but there is a a summary document as well that goes with it, which is 30 pages and picks out highlights. But what I found when looking at the two of them side by side is that a lot of the information SOS law is going to be in the bigger document for our sector. It just glances over, very generally in the summary. But I'm sure we can get those slides out to everybody today that's attended. I think we're. Oh, you're very welcome, Terry. Thanks very much for coming.
Thank you.
And thanks to everybody else as well. As I say, you've got our details, you'll have the slides if you want to continue the conversation. I know there's various sort of musings about working groups being set up, but I think that's really important to share views as well on this, because we've experienced internally with contempt proceedings in certain courts, others may as well. So it's good to have those conversations. But yeah, for the time being, then, if we leave it there, we're 2 minutes out. Kirst, I think we've done really well. Thank you all for staying, joining us today.
Yeah, thank you very much. See you
Have a
soon,
good
guys.
day, everyone. Bye. Bye.